Good afternoon, everyone. We're going to call to order. Am I off? I'm not in the right one. Okay. Where's mine? Okay, there's mine. Good morning, everyone. Good afternoon, everyone. Today is Thursday, December 3rd, 2015. This is the Board of Liquor License Commissioners for Baltimore City. It's our 1 p.m. docket. Chairman, I know that you probably wanted a separate item before we start the docket today.
Correct.
Okay.
Thank you. I don't know, is Shannon Wren here? No. Shannon Wren apparently wrote an article which appeared as an editorial in the Baltimore Sun and indicated that apparently some believed that I said that MOUs were not enforceable. The case she pointed out correctly was the Maryland Court of Appeals, Baltimore Liquor Board versus Fells Point Cafe, and quotes that the board may place restrictions on a license with the consent of the licensee, unquote. And that is exactly what I have done in those cases, and I've asked the licensee if they have agreed to those restrictions. And in almost all of the cases, they've had attorneys and counsel, and I've asked them if they've agreed, and they have, and that's become part of the record and part of the licenses. So I think that this is a misquote and probably a misunderstanding of some people, and so I just wanted to clarify the record for that. All right?
Okay. Chairman, the first item is item number 1 of the regular docket. So that's Warren Rogers and Charles Bennett and Geneva Brown, Eastside Reindeer Association, Inc., trade name Eastside Reindeer Association. This is at 1228 East Preston Street. You can come on up. A Class C, beer, wine, and liquor, a request for hardship extension. I'll just get you right there. You can just go right to the microphone. I believe you're one of the licensees.
I'm Bennett.
Just for the record, I'm sorry, that I may have misstated something or didn't state something, but that on the licenses where the licensees agree to an MOU, that is enforceable by the board, okay? Because that's part of the license restrictions, okay? Sorry, I'm sorry.
Okay.
Okay.
So this is for Eastside Reindeers. This is a hardship extension request under provision 2B 10504D. I believe Mr. Bennett is in front of us, right? Are you Mr. Bennett?
I am Bennett.
Thank you,
yes.
Mr. Bennett. So we have a copy of the letter from the saying that they have that they've been fixing the establishment, but they have not been able to be open, and they're asking for a hardship extension in the appropriate time underneath the rules. And so the staff has submitted this for your consideration and possible approval.
Mr. Bennett, let's have you sworn in, please. Raise your right hand.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Now, would you give us, please, Mr. Bennett, just a brief explanation about the financial hardship and why you're asking for the extension?
Okay. The building is very old, and we had rain damage, water damage, and structural damage, actually. Okay. Now, my question is this. We are trying to get out of the building, get away from the building. However, we have extensive debt with the city. And my question is, they want to know if we can keep the license and move to another area, I think. That's a transfer. Transfer, yes.
And because this is a Class C, it has a legislative, there's also a legislative component to it. So in regards to that, I think that it's best to, one, if we would grant the hardship and then work legislatively with your senator in regards to the movement of the license
Yes.
to another location.
Another location.
And that's the reason why they asked for the hardship from the board.
This is the reason why we
Right, I understand.
Mhm.
Okay. Questions from the commissioners?
How long have you been out?
Since April.
And it was because of water damage to the
Well,
ground?
yeah, structural damage. What happened was the city came and cut the grass around the area, right? And the next day we noticed that there was damage to the exterior of the building. And with that in mind, and the water damage, and
The grass was that high?
the grass was that high. The grass was that high. Yeah. The city, you know,
Grass.
something like that. And this is why we are asking, and we can.
And you're in debt to the city?
Well, I wonder if I should say all this, but it went up for tax sale at one time, and we are paying the city back. We have made arrangements with the city to pay it back, $250 a month,
And just for the record, the request was made on October 2nd, so that the request is in regards to the fact that 6 months from the October 2nd date. So that would be, so that's where your 6 months would start.
And the tall grass would be a miscellaneous.
That's that. Yeah,
Yeah,
that's
I mean, they come out and
miscellaneous.
mow
That
it
has
and
nothing. Yeah, that has nothing.
But it acts as it acts as a tax. It's $100 or $150, and they assess it to the
Right.
property.
Mhm.
Right. I understand.
Okay. Hmm.
All right.
And we're trying to sell what you know, the building that's there, and transfer, move to find another location.
I understand.
No questions.
I think that it complies with the hardship requirements under 2B, and I'm a yes.
I'm a yes.
I'm a yes.
Step down there and see that. See the.
Actually, Miss
Oh, in the back. I'm
Miss
sorry.
Miss Russell in the back. Thank you so much, sir.
Okay, thank you.
Thank you.
Thank you.
Farmhouse Diner.
Okay. The next one is Corey Pagliocca, Farmhouse Diner and Oyster Shed, LLC. Trade name is Shoefly. That's at 510 East Belvedere Avenue, a Class B beer, wine, liquor license. This is also a request for hardship extension under 2B 10504D.
Counsel.
Good afternoon, Mr. Chairman and Commissioners. My name is Joe Woolman. I'm here on behalf of the licensee who's standing to my right. I believe he can offer a brief statement as to the hardship the operation has faced and their efforts to reopen in the near future.
All right, let's have him sworn. After he takes a drink.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
And you are?
My name's Corey. I'm the owner and operator of Shoefly.
Okay. Polyoka.
Yes, sir.
Okay. Go ahead.
So we operated Shoefly. I'm part of a restaurant group, and we started with a restaurant called Woodbury. Spike and I attempted to do Shoefly. It was a move where we were taking the same ingredients that we were doing at our other restaurant and we're trying them at a new price point in a new market. We had some challenges with our cost of goods sold and our occupancy cost, which caused us to run a loss. So at the time, we stopped operations there. But we're continuing to do our canning, which we were doing in the back of that building and continued to do and operate it that way. And we're working on thinking of a new concept and potentially a new capital raise to rebrand Shoefly into something that had a better cost of goods sold.
What do you do in the back?
Canning. So we have a Maryland State approved cannery that buys some local farms and makes jams, jellies, pickles, snake oil, hot sauce.
Okay.
That's part of the reason why we went into that building was they had a separate kitchen that we could use.
This
for
used
that.
to be Crush.
It was the Crush building, yes, sir.
And the hardship is that you ran out of money.
That with the Shoefly concept, yeah, yep. So we were looking to
Keep the
potentially
license
change
there.
that and
Keep a liquor license there.
yep, and then not do the diner price point, which is what we had attempted with Shoefly. It's important to us to have local food exist in a lot of different restaurants and different price points, and that's something that we've been focused on in our group.
So this is a group of restaurants, or is this one of a group of restaurants?
This is one restaurant.
One restaurant.
Shoefly, yeah.
Different, separate license altogether.
Correct.
Okay.
Are we fine with the timing, Madam Secretary?
Yes, this was requested in October, and I believe the operation ceased in
Late
like
May,
late May.
correct.
Yeah,
After Preakness, yeah.
right.
And when did your operation stop? And
There was a Preakness party May 17th, and May 24th, I think, was the last
Right.
day we operated.
and did you redo the interior of that place?
Originally, when we first took it over, yeah. We changed some kitchen equipment. We changed the bar layout on the front, the dining room upstairs.
What was the layout of Capitol?
We were 371, I think, in.
No questions?
Any questions?
I think that it complies with requirements under Article 2B, and I'm a yes.
I'm a yes.
Thank you.
Thank you.
Thank you.
Thank you.
Belvedere Square,
Yeah.
good area. We need to push that.
No, I understand.
Got it
Okay.
great.
The next item is Kenneth Plant, Dead End Bar and Grill. No, sorry, I got the wrong island. Nancy Mola and Richard Deal, Gunther Boiler Works LLC, at 211 South Conkling. This is a Class BD7 beer, wine, and liquor. An application for transfer of ownership under BD7 license, presently located at 2320-22 Boston Street to 1211 Conkling Street, and also a request for live entertainment, outdoor table service, and outdoor catering. Thank you. And off-premises catering, excuse me, not outdoor, off-premises. Thank you.
Mr. Fine, are you going to have testimony from individuals, or are you going to offer a proffer, or how are we going
I
to proceed?
would like to do a proffer. We have letters of support from the Canton Community Association and the Brewers Hill Community Association, and I don't see anyone coming forward to protest this license application. So if the board pleases, I would like to make a proffer.
That's fine.
Mr. Chairman, my name is Stanley Fine. With me is my colleague Justin Williams. We're from the law firm of Rosenberg Martin Greenberg. With me today are Nancy Hart-Mola, one of the licensee applicants, and Richard Luther Frederick Deal, the other licensee applicant. Also, David Nipp is here as the landlord of this property. This is an application for transfer of the BD7 license of the Fork and Wrench. Ms. Hart would be our first witness, and she would testify that we are applying for the transfer of the Class D beer and a BD7 license at Gunther Boiling Works LLC is the applicant. In your file, which I've given you, is a certificate of good standing for the LLC that's going to own the license, and Mr. Deal and Ms. Mola are the licensees. The Gunther Building Restaurant is located in Brewers Hill in the historic Gunther Brewing Company building. And the restaurant will cater to the residents that are in the Gunther building and the nearby residents in the Hanover project and other apartments and residential dwellings. The restaurant will feature a menu with modern American cuisine and oyster bar, and we provided you a sample menu. We provided you a copy of a photo of what the restaurant looks like on the outside, and we've also provided you a plan unit development ordinance and plan. And when you look through the plan unit development ordinance, you'll see on page 5 that both live entertainment that we're requesting and also outdoor seating that we're requesting is a permitted use as a matter of right, subject to getting, obviously, approval by the liquor board on our license. You also will see in the file a couple articles, one from the Baltimore Business Journal and one from the Baltimore Sun, where it quotes Ms. Mola as the soon-to-be operator of this restaurant and how the restaurant is going to be managed and what it's going to be comprised of. You also have a copy of a floor plan, which basically shows the first floor dining and bar areas, and you'll see a mezzanine, and there is an outdoor seating plan. The floor plan shows the following: 132 total seats at tables, and including 16 countertop seats and 52 seats on the mezzanine level. In addition, the bar on the first floor will have 24 seats, and there will be 50 seats at tables, and 8 bar stools will be provided in the outdoor area. The restaurant will offer lunch and dinner Monday through Friday, and on weekends, brunch and dinner. and under the terms of the lease that they have with their landlord, no one may be seated for meals after midnight, and the establishment must close no later than 2 a.m., which is the law anyway. You also see in your file as an exhibit a budget which shows that this new investment here in Baltimore City is approximately $3.2 million, which both the landlord and tenant are sharing in developing this project, as well as additional soft costs. They do plan to offer live entertainment, which is being requested, and it will be on occasion. It won't be constant. And again, pursuant to the terms of their lease with their landlord, because there are other people living in Brewers Hill in this project, the licensee applicant will not operate live music outdoors later than 10 p.m. and indoors with doors and windows closed no later than 11 p.m. Ms. Mola, who was here, will testify that she'd be the general manager of the restaurant and will be responsible for the day-to-day operations of the restaurant. In the file also is a resume of Ms. Mola. She has more than 20 years' experience working in restaurants in various positions, including chef and operations manager. Their policy with regard to carding people will be that they will plan to card everyone who appears to be under 35. They will complete, Ms. Mola will complete an alcoholic beverage safety training course. Why is there a need for this license? There is this beautiful space in the Gunther building that just lends itself for a restaurant, and it is something that Brewers Hill needs a quality craft beer selection to go along with a diverse restaurant menu. And obviously, the ability to serve alcoholic beverages in connection with a restaurant is necessary to enhance the restaurant's appeal. You also see in the file that Ms. Mola has met with both community associations, namely the Canton Community Association and the Brewers Hill Association, and there are letters of support. And most recently, the library in Canton, which is closed, which is behind O'Donnell Square, had a fundraiser, and Ms. Mola and her group participated in it, and the Enoch Pratt Library folks were very supportive and have also submitted a letter of support. Finally, Ms. Mola would testify that the application that she submitted to the board is correct and accurate, and she has reviewed the rules and regulations of the City Liquor Board and agrees to abide by them. Our second witness would be Mr. Deal, who would basically corroborate and confirm everything that Ms. Hart has said, Ms. Hart Mola has said. And that would be our proffer, and we think we meet the criteria that the board has in approving a transfer of a Class D license. And I can, in my file, in your file is a summary of the conclusion of how we do meet those criteria at the end of our presentation, which is the first piece of paper in your file on page 5. Ms. Mola is here to answer any questions, as is Mr. Deal. That would be the end of our submission.
I just have one question. I may not have heard. Live entertainment?
Yes.
Went to the zoning already for that?
If you look at the plan unit development, that is on page 5.
Yeah, I see
A
the
restaurant with live entertainment, we've highlighted it in yellow, is a permitted use as a matter of right under the PUD.
zoning give it to us?
So we don't have to
Under
go
the
to the
PUD.
zoning board. We don't have to go to the zoning board, but just because we have the zoning for it doesn't mean we can do it unless the liquor board approves it.
Right, okay, so it's part of the PUD, so you're
Yes.
coming to, okay.
It's highlighted in yellow.
I see it.
Okay.
Who owns the LLC?
Who owns the, Ms. Hart and her investors.
And they, okay, how is the money, the $3 million being raised? Is it loans?
Uh,
No, we have to, you can't testify without being sworn in.
Oh, we've got to be sworn in.
She's gonna be sworn in, or you're gonna proffer, whatever.
The $3.2 million, and it's actually a little bit more than that because it doesn't include soft costs, under the lease arrangement that they have with the landlord, and Mr. Deal is a representative of the landlord, and he's on the license. The landlord is contributing a certain amount, and the tenant is contributing a certain amount. So that's, if you want to know the specific amounts, I'll ask Mr. Deal or Mr. Nip to answer the question, but the $3.2 million plus is a combination of landlord allowances, landlord improvements, and tenant improvements.
Tenant improvements, but there's a certain amount of cash being given to somebody, you know? And is that through personal finances or loans or?
Yeah, but
Swear 'em in.
We're gonna have to
why don't you swear both?
swear both of 'em in.
Because I think they can
Yeah,
answer the question
Okay,
better than I.
that's fine.
Okay. Raise your right hands, both of you.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
So is it bank loans?
Identify yourself.
I'm Nancy Hart Mola, called by both last names. Currently, the landlord has agreed to put in $1.25 million, that is in our lease. The additional funds, my business partners are able to fund completely. We might take on investors. It has not been determined yet. Obviously, all that information would be shared with you. But
But
currently,
the
my
LLC has limited partners? What type of partners are
It
taking
is-
money into this? I'm just trying to follow the money trail.
In LLC, you have members.
I know, I own LLC.
Right,
Right.
and so members of the LLC will be contributing money and getting in turn a percentage of the business.
And have you declared who your partners are in the LLC?
we have not.
We would like to see the partners in the LLC.
I'm sorry. Currently, their LLC.
Identify yourself.
Identify yourself,
Richard Deal.
because he's recording and
Okay,
the
sorry.
recorder can't tell.
The LLC has a general partner who has shown to us, the landlord, substantial personal ability to fund their share of the build-out, and they've proceeded with their build-out and have funded up to this date. And our 1.25 is out of our bank account that we have funds from operations of the
Yeah,
existing
what,
property.
what I'm concerned about
Yes, sir.
is having the rest of the money by a general partner of the LLC given to you that we don't know about.
Oh, okay.
It could be out of Philadelphia, it could be out of New York, it could be any place.
You want the information of,
Yeah, we would like to see the financial information of the LLC. And that will be a condition of the license, most probably, or the transfer.
can absolutely
Okay, I just
provide you
want
that
to,
information.
want to see that.
Right.
Okay.
And that should go in the checklist.
It should go on the checklist.
Okay, that's fine. We can certainly do that.
And just for a matter of record, that Exhibit 1 that Mr. Fine presented, I'd like to just number that for the file, is that he's provided the information in regards to his testimony, the PUD information, the menu, the photos, the article from the Business Journal, and other information and letters of support are all part of Exhibit 1 for the file, just in general, so that we have that into the file.
Collective Exhibit 1.
Thank you.
Right.
Thank you.
And based on those conditions, I have no problem.
I don't have any problems either. I'm a yes.
Yes.
Mr. Fine, I think you met the requirements under Article 2B, and I'm a yes. Assuming we've got the one additional condition.
Of course.
Right, okay. Okay.
Thank you very much.
Thank you very much.
Thank you.
Sorry about that one. I'm sorry that was missing. I was like, that's just weird.
That's okay, that's okay. I just was looking for it, I couldn't
Yeah,
find
me
it.
neither. I was like,
It was, Luke sent it in our package last week.
You what? Okay, well,
Just got mixed up.
sorry. Yeah, it's been in a couple packages, so,
It's all right.
it wasn't in this package, though.
yeah. I must have mixed it up with the two packages.
Okay, what's next?
Okay, you ready? Kenneth Plant, Dead End Bar and Grill, LLC, trade name, Dead End. This is at 933-35 Fell Street, a Class B, a new Class B, beer, wine, and liquor, an application for a new Class B, beer, wine, and liquor under Article 2B, 6-201D, 7, with $500,000 in capital investment in restaurant fixtures, furnitures, and facility, and a seating capacity of at least 75 people.
For the record,
Oh, yeah. So let's say I just want to make sure to note that we did get some letters of opposition, and I just
we got
want-
a preliminary on this.
Preliminary.
Okay, and then we've got Mr. Lauer,
Lauer.
who is also counsel, but you're opposed. I
Yeah.
just want to get the
Well, that's what we
point
just want to put on the
That's
record.
correct, Mr. Chairman.
Now, do you have witnesses that are going to testify, or you going to proffer?
No, we worked at something. If you
Okay.
just listen for a second.
Go ahead.
Easier than that, Mr. Chairman.
All right, go ahead.
The director says he never hears me speaking into the microphone.
He can see you, though.
I can't see him.
All right.
Melvin J. Kanensky representing the licensee.
Fred Lauer, representing Mr. Jabko and some residents of the community.
This would be a joint request for a postponement. There were some, as Russ Limbaugh would say, issues that have developed that they're going to try to straighten out. Plus, there's going to be amended plan to just use the first floor. So there'd be a joint request. Let the community through Mr. Lauer and the building owner meet, and if it's straightened out, we'll put it back in. You're only doing 10th and 17th.
Yes, sir. What date are you asking
No,
for?
we'll go see how far we get.
Okay.
If we make what they say
Because
progress.
the 17th has already been posted. That's end of 10th.
I understand that. So I mentioned that to Mr. Lauer, but I would probably think it's going to be after the first of the year.
Okay.
Start off the new year right.
Which gets posted the 23rd of December.
Thank you very much.
Thank you.
Now, I have one question. Is this the one involving the environmental protection letter?
Yes.
EPA?
Well, there's a letter in the
There's a
file.
letter
Yeah.
in the file about,
Excuse me.
we don't know who you are. You're not under
Mr.
oath.
Chairman.
Mox
Mr.
next.
Chairman, if I might, I think there's a letter of that sort in the file. That's all I'd say. And we agree with the postponement.
Okay, all right, okay.
And everything will be addressed.
We're trying our best to address it, and then the communications outside were very positive.
Okay,
Best efforts.
all right,
That's first.
okay, that's a good
Unless
one.
you'd rather hear
Good
a
one.
3-hour case. No. we'll postpone.
No, that's fine.
All right,
Thank you.
Thank you.
Thank you.
see you later. I just wasn't sure that that was the same one.
It is the same
It
one.
is, it's the same one. Boy, look at that. Ooh,
Cleared you out.
oh my God, the whole, huh? I don't know what the EPA is.
Environmental protection.
Oh, I know that.
I don't know what that issue is.
Now you're an EPA lawyer. You're gonna be out there measuring rain discharge. Got half the thing left.
Okay,
Hey,
How popular you were.
okay,
you ready?
yeah.
Mark Gentile, Tim Winstead, and Scott Donnelly. This is Little Havana Management, trade name Little Havana, at 1325 Key Highway. This is a Class BD7, beer, wine, and liquor, an application for transfer of ownership from 1501 Covington Street.
No, obviously, do we have an attorney? No.
No.
Then we're all gonna testify.
You swear or affirm the testimony you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth? Just one person answer questions, please.
Yes, one at a time, and give your name. Who's going first?
I will.
Step up, talk into the microphone, give your name.
Mark Gentile, that's MarcGentile.
Okay. Go ahead, Mr. Gentile.
Basically, we have existed for almost 20 years with our current license. Our current license prohibits off-premise sales. We got a chance to pick up a license around the corner up on Covington Street, bought that, and want to move it into the location. That is
Transfer that license into the,
correct.
your location. Okay. So we will get rid of one license
Well,
or expand a license?
How does that work?
so then they would actually have the opportunity to possibly transfer their existing B to someone else if they do so within the given period of time.
Which is how much, 180 days?
Yes, they'd have to, someone needs to make well, it depends on the time of the transfer, so we have time, they have 100 days to finish this transfer because they will still be operating under their B until this transfer is complete. Then once that period of time, so it will be rolling depending on when they finish this completed transfer. So if they finish it within the first 180 days, which they need to for the BD7, then 180 days later, after that date, the B would have to be transferred.
Got it?
So,
So you're going to modify your store or your location to handle all premise sales?
I wouldn't say we would particularly. It's a large place. We have a lot of storage. I'm not even sure how much this would come into play right now. We have the opportunity. There's a large marina right in front of us. We have the opportunity. People like to go back to their boats, want to bring beer or wine with them. We'd be able to do that now. But I think we agreed at the time that there was a good price on this license, and we thought that this license would help increase the worth of our business overall, and decided to make the move at that point.
and they no longer have a food requirement as a restaurant with the BD7, so it would change the the type of their operations. They would no longer have a requirement to have 50% food with the
But you
BD7.
have to have a tavern.
Right, they will have a tavern operating. That's what they're going to be operating as a a restaurant tavern. So they would, but they no longer have the food requirement under their and have to submit the food forms
Right.
as a B.
Are there any letters from the community or?
I do
I
have
believe-
some letters in hand here. Admittedly, this process is a redacted form of what we'd set out to do originally, which was to increase our footprint within the building and add a small
Put up-
cafe up front. So you'll see that. What was that, a microphone problem?
Microphone.
Sorry. So I have, this is Federal Hill South. No, sorry, this is Federal Hill South and this is Riverside. The Riverside letter is addressed to David Tanner, but all the information is still in there. It all relates to the same matter. It mentions off-premise sales. Sorry about this.
These aren't signed. Do you have executed ones?
No, I'm sorry. I'm sorry I don't.
And-
I can get those and submit them, but.
Yes, we
the
want you
spirit is
to
there.
submit
The spirit
them.
of the letter is there. That's interesting.
Besides, Mr. Tanner's with the zoning board.
I realize that. Like I was saying, the process we were going through was to have zoning allow us to expand our size. We had an issue, like a parking snafu, so we've delayed that just to get this done so that the license that we've purchased, we're not even exactly sure how long that restaurant or that bar is out of business, but we want to make sure we don't run into any problems.
And so their original application, they had the expansion, but that has been removed from this application. So it's just a straight transfer of the BD7 to this location, and no longer they are requesting the expansion of the premises.
All right, we'll come back to do that at a later date. As I said, we've been in business for close to 20 years. We've not had any problems. I don't see this changing the way we operate in hardly
No.
any ways.
Was there a question about violations?
Right. So no, and as part of the license file, I included a copy of their, that in 2008, they had actually had a conference, but there were no, where we granted them to add off-premises catering as a Class B. As a BD7, they don't need to have those additions. So, but that was the last time they were in front of the board, and they've had no violations.
And they can have off-premises catering now?
Yeah, it's for Bs. There are certain class additions that you have to do, but BD7s don't have those same class additions.
So before, as a condition, we do want you to submit letters, sign letters.
I will get them signed. They were emailed to me like this. I never even thought of it.
Yeah, and he will have to go to zoning and when they get a new use and occupancy, because currently on his license it has some restrictions in regards to the food requirement and to the existing restaurant issues. So when he goes, he's aware that he needs to go to zoning and has made that application so that he can operate under his new class type.
Got it?
I do.
Okay. And with those caveats, with the letters signed, I noticed for the record, they were in support, but they weren't signed. And the zoning. Okay.
Correct.
I believe that you met the requirements under Article 2B, and I'm a yes.
I mean, yes.
And the licensees are going to be the same on your original license?
Correct.
And the ownership will be the same?
Correct.
Okay. I'm a yes.
Okay.
All right. Thank you very
Good
much for your
day.
time.
Thank you.
Violations.
Violations docket.
Violation.
Margarita del Rosario, that's the first one. That's
Uh-huh.
okay.
Which one's
This Sandbar, is that postponed?
That has been postponed.
Yeah.
Yeah, it's on your next docket. Yeah, I think that's what inadvertently was swapped.
Mm.
Gunther and Sandbar in
Right.
this one. That's
Yeah.
why I noticed it was wrong. Yeah, violations, sorry. The first item on the violations docket is Margarita del Rosario. Trade name is El Deportivo Sports Bar. That's at 110 South Haven Street. It's a Class BD7, beer, wine, and liquor. And this is a charge for illegal conduct that occurred on November 8th, 2015. As part of the allegations, at approximately 12:30 in the a.m., the BLC inspectors, Chrysomalis, Karanakolis, Howard, and Foster, made an observation that someone urinated in front of the establishment about 4 feet away from the inspectors, and there was video footage of the incident. And then they also noted that there was no live entertainment in the establishment and allowed, and this also did not include dancing. Then the inspectors advised the licensee of the violation and left the location.
I have a question,
Yes, sir.
which is, no, not of you,
Okay.
which is Ms. Della Rosario. That's you. Do you contest the fact that someone went out and urinated, relieved themselves outside?
Excuse me,
Yeah.
she don't speak English, so I was.
Okay, well then, in that case, let's have everybody sworn in.
And the sworn translator.
And you, and her as the translator.
Do you swear or affirm, raise your right hands, please, raise your right hands. Do you swear or affirm the testimony you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes,
And as the translator, do you swear to translate this hearing correctly?
yes, I do.
Okay, now, does she contest the fact that someone went out there and relieved themselves?
Y si tú contestas en
translator's
referencia a que te dijeron que
I'll
alguien se
get it,
orinó
I'll get
fuera de la casa. Yes.
Yes. Okay, all right, that's all I need to know.
Real quickly, what is your name, ma'am?
Remedio Zapata,
Could you spell that for?
R-E-M-E, D as in David, I-O-S, Zapata, Z as in zebra, A, P as in Paul, A, T as in Tom.
Your first name again? I did not get it.
R-E,
Just
M-
spell it, just R-E.
M-E, D as in David, I-O-S.
Thank you.
You're welcome.
All right, who's going to go first? Mr. Fosler.
Oh, thank you, ma'am.
Agent Mark Fossler, Baltimore City Liquor Board. On November 8th, 2015, approximately 12:30 a.m., Inspector Krista Miles, agents John Howard and myself were conducting a special investigation of the establishment El Dorpurvito Sports Bar. This was based on prior observations by inspectors that initiated this investigation. We observed security at the front door checking patrons as they entered the bar. Security was generally immediately inside the front door. During the time of our observation, we observed a male patron exit the front door. He went approximately 4 feet to his left from the front door and began to urinate on the front of the building. Inspector Krista Miles videotaped this activity, which he'll show you at the conclusion of this report. Approximately 15 minutes after the public urination, man and woman came walking down the street, and include this because this plays into the public.
You put in whatever you want.
The woman was leading a child about 4 years old. The male was carrying an infant, and they entered the home immediately next to the bar. So we then entered the establishment. Agent Howard took photos of patrons dancing. We went outside with the manager and licensee. We advised them of the licensee. The music was very loud at that time too. We directed the manager to lower the volume of the music. They complied. We considered that abated. So then, after showing them the video of the public urination, we departed without incident.
Did you testify, I may have missed it, after the alleged offense where this individual went?
I'm sorry, I did not, but he immediately entered the establishment, re-entered the establishment.
All right.
So you saw him leave the establishment, urinate, go back into the establishment.
That's Commissioner Trotter. He exited the front door, urinated, and then immediately went back inside the front door. That's correct.
Okay. Now, your client has an opportunity, if she wants to ask Agent Fosler any questions. Okay?
Es el que tú tienes la oportunidad de hacerle preguntas ahí si tú gustas.
Dile que
Que no, que yo entiendo que yo vi el video, pero que como él no entiende, yo estoy adentro de la caja y no me doy cuenta de lo que está pasando afuera.
I agree to what he's saying because he showed me the video. He said, but I also want you to know that I'm inside. I can see what happens outside.
Okay. All right. Any other questions?
¿Tienes alguna otra pregunta?
Y referente al baile, era persona que cuando yo salí a ver el video, fue que entró el otro inspector y cuando lo encontró bailando, pero que allá no se baila. Lo que pasa que como estaba yo afuera viendo el video, ellos se me escaparon y era bailando en el pasillo.
Okay. In reference to the people that were dancing inside, when I went outside to see the video, that's when they did that. I usually don't allow no one to do that. When they start, I usually tell them to stop. They usually stops, and if they don't, I ask them to leave.
Okay, but you weren't violated for the dancing, right?
Right.
It was not violated for the dancing.
No, yes, that's, no.
That abated, right?
And
No.
the loud music was abated.
The loud music was, we
The
didn't violate
only
for
thing
that.
we're here for is the public urination. The way I understand it is that your client saw the video, doesn't contest that the gentleman urinated, but she says she was inside and didn't see it.
Dice solamente que estabas adentro y
Correct?
no lo viste orinar. Yes, sir.
Correct. Okay. So, do we need to see the video if she's already admitted to, do you want to see the video? I don't think I need to see the video. No. So the question then is, just on the violation of illegal conduct, is the licensee responsible for the gentleman who goes outside and relieves himself and comes back inside?
I have a question.
Yeah, sure.
Was there anything wrong with the bathrooms inside? Were they operational?
Okay, ella está preguntando que si había algo mal con los baños adentro, que él
No.
tuvo que salirse fuera.
No.
No, they were not.
So the patrons had the capacity to go inside
Yes, sir.
and use the rest facilities inside their bar.
Yes.
Dile que los inspectores habían ido y habían chequeado todo estaba bien.
Está preguntando él que los baños estaban en buenas condiciones, que él podía haber ido al baño allá adentro, no tenía que por qué ir.
Todo está en buena condición.
Yes, sir.
Okay. I'm going to defer to the other commissioners before I vote.
And this is they don't have a history of any violations, right?
No previous violations for this licensee.
What about
Contestaron que no.
what about 311 calls or complaints?
Commissioner Hayfie, there's been a couple 311 calls that we responded to for loud music, but nothing that hasn't been, abated immediately.
Yeah, why was a special investigation called for?
The Commissioner Trial, the previous week was Halloween night, and while responding to a complaint, had gone by the place, and there was quite a few people outside, and believed at that time that there might have been some outdoor open containers outside, because I was responding to another complaint, and things were kind of jumping that night, Halloween night, that I decided that the following week that we would initiate a special investigation to determine exactly what was going on. Yes, sir.
Did your client hear everything? Did you interpret everything that he said?
As he talks at the-
Okay. All right.
So as far as a determination, a finding, I don't know if we've ruled on that, but she's not contesting it.
Violation.
So it's a violation, just to make the record clear.
There's no history of violations in the past?
No, and this was transferred in 2010, so they've been
So
in
we
business for
can go
5
from
years.
0 to 500, correct? Okay.
Exactly.
All right.
Well, the only comment that I have is that the bar owner is responsible for the patrons inside. And what they've done is allow basically a public, not only a public nuisance, a public health hazard to exist in that community, which is unacceptable, is totally unacceptable, in my opinion. And I would say it's a violation.
Well,
And
it's not really a violation. She didn't oppose, she didn't.
I would say it's,
Right,
The question is the fine.
right.
I would,
Since there's no
previous.
previous history,
250?
250 is fine.
With 125 administrative.
Yes.
That would have to be.
And 30 days to pay.
Yeah, 30 days to pay.
And take control of your patrons. Don't let, you have facilities, don't let that guy in again, or that person, I don't know if it's.
You know who he is.
Have a family walk through that. Oof.
There she goes.
Listen to me. She's not being suspended. She's not losing her license. She's getting a fine.
Administrative
Okay?
costs.
Administrative cost. But she needs to take better control of her people and lay down the law. Okay? Okay?
Yeah, she's saying, I tells them, but they don't pay me no mind. Eventually, she needs more control.
We just don't let the person in again.
Okay. All right, thank you.
Thank you.
Thank you.
Anything she waits, needs to wait for, nothing?
Thank you,
That's it.
inspectors.
She has to see the people in back.
Okay, thank
No,
you.
she's got everything. She can pay it. She's got 30 days to pay it.
It is 30 days.
Mhm.
Okay.
You're welcome.
Thank you. Glad we didn't have to watch the video.
Yeah, I didn't want to watch this video.
Wish you would contested it. We would have to.
Right.
Yeah, that's, Walton has been postponed, correct?
Walton is postponed. So the one for Walton has been postponed until February.
Okay.
The next one is Angel Anaya, and this is AAA Limited. And this is AAA Liquors and Packaging Good. That's at 2101 Angel. Sorry. This is a Class A beer, wine, and liquor. On October 25th, the violation of 4.1A. On October 25th at approximately 2:30 p.m., Inspector John Howard responded to the establishment because of complaints that he received that this establishment was opened on a Sunday. Upon arrival, Inspector Howard observed the establishment to be open and operating. He asked and received a 24-ounce beer for purchase. He then identified the licensee, Angela Anelli, and informed her that the Class A establishment without a special Sunday permit is not allowed to operate on Sundays. I believe Mr. Howard is here to make his presentation.
Now, first of all, let's have all three people sworn in. Raise your right hands.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Now, you're Miss Ayeni? Yes. Now, Miss Ayeni, my first question to you is, do you dispute what you have heard, what Mr. Howard is alleging to have occurred? That's my first question.
And this is an honest mistake, sir, because
No, I didn't ask you if it was a mistake. I'm asking you if you disputed whether or not he came by and said you were open, and then you closed, and then he came back and you were open again. Yes or no?
yes,
You were open again. And you admit that. Okay. So now, she's admitted the violation. What?
Right.
I
Go ahead.
wasn't clear. You asked her whether she disputes it.
Right, but she
Said
She
yes.
said yes, she disputes it.
she disputes whether or not she reopened?
No.
You ask her.
Are you admitting, do you admit to the violation, to the allegations?
Were you open?
Were you open?
yeah, because they broke into my store. I was opened.
For sales?
For sale.
Let's let her testify.
Why don't we just have the presentation and
Fine,
then
fine, go ahead,
go from there?
go ahead.
Good afternoon. Agent John Howard, Baltimore City Liquor Board. On October the 25th at about 2 o'clock, I received a call stating that the Triangle Liquors was open and operating on a Sunday. And so I responded to that call, and at approximately 2:30, let's see, let me just read my report.
Go ahead, take your time.
Agent John Howard received telephone calls stating that licensee has been opening up for business on Sunday illegally. This license is in LA. It allows them to operate 6 days a week from 6 a.m. to 12 midnight only. Upon arriving at the establishment at approximately 2:30, I observed the gated security door and the front door open. I entered, asked for and received a 24-ounce bottle of beer. I identified myself and informed Miss Ayeni that her license did not allow her to open or to operate on Sunday, and that she was open in violation of restrictions placed on her license. She stated that she had just left church and stopped at the store to use the computer. I instructed Miss Ayeni to close and gave warning not to reopen on Sunday. Later, at approximately 7:30 to 7:45, I received another call stating that the licensee had reopened after being told that she would be charged with a violation if she were to reopen on Sundays without special permission. Upon arriving at the location, I again observed the same two doors open. I entered the store and informed Ms. Ayeni that she had to close again and that a violation of the liquor laws prohibiting operating on Sunday would be issued. I requested Ms. Ayeni to sign the violation form, which she refused. And agent issued violation for operating during prohibited hours.
Now, Mr. Howard, I have a question.
Yeah.
How do we know that she was in operation when you went back, as opposed to just being open and cleaning up or watching the TV or doing whatever she was doing? How do we know that?
Well, when I went back
The second time?
the second time, I entered the store and she was behind the counter and said, "Yes, can I help you?"
Okay.
Did you attempt to purchase something?
Not the second time.
Okay.
Enough beer that day?
Were there any other patrons in the establishment?
No. When I came back, no.
But the first time there were other people there?
At the first time, no, there weren't when I walked in. But while I was there, some people did come in, and she told them that she couldn't serve them.
What do you mean she told them that she couldn't serve? After you had instructed her?
Yeah, while I was in there, you know.
First time or the second time?
The first time, while I was doing my initial investigation.
So at that point, you had announced to her who you were.
Yes.
And then people came in, and that's when she said she
Yeah.
can't serve them.
Correct.
Okay. Do you have any questions for Inspector Howard?
He came to my store.
Step up to the microphone, please. Go to the microphone. There you
Okay,
go.
he came to my store, and I don't open on Sundays, but on Saturday night they broke into my store, and I was coming from the church, and I called my brother that this is exactly what happened. My brother said I have to wait until you come and see it, and then I was sitting down, and Mr. Howard came. He said he wanted 24 ounce Bud Ice, and I gave it to him. He said, "Madam, I'm not supposed to do this thing because I'm not supposed to open on Sunday." I said, "It is true," and I begged him, not to take me to Board of Liquor because I'm so scared. So he told me to close the door, and I closed the door. I closed the door, but my brother called me at maybe around 7.
You stepped away from the microphone again. Step
Okay,
up.
say he be coming to pick me up, and I just opened the door. When he asked me to close the door, I closed that door. But my brother says on his way, and I opened the door, and in about 15 minutes, this is around 8 o'clock. I've never seen any inspector to be visiting a retailer at 8 o'clock before, because I've been in that store for over 17 years, and I never had any problem like this before. So I say, I didn't even know it's him, and I say, excuse me, go back. I'm waiting for my brother to come and pick me up. And Mr. Howard just, the first time, is a very nice, cool man, but Mr. Howard lost control. I have to close my door. He went to his car. I was begging him, please, don't lose control like this. I'm not selling anything. I was waiting for my brother, but he was so upset with me, and ever since then I've been so sad, because I don't want trouble with nobody. I don't have any, I'm a very nice woman, and then I give credit to some of my customers. They owe me so much money, and the people that organized to break into my store, I have an alarm. They drilled, they went to the second floor, and they came through the wall, and about last Sunday, they slashed my tire, and only yesterday, they came and cut the cord for my computer. Somebody is the same man who probably called Mr. Howard, They don't like me, but I like them. I don't give them credit no more. So that's exactly what they are trying to do and hurt me. I'm a nice woman.
So Mr. Howard's testimony was that when he went into the establishment, you said, "May I help you?" Is that incorrect?
Yeah, he came to the window. He said he wanted.
No, you got to step up to the microphone, man.
Yes.
That's incorrect. He didn't say that at all.
He said he want to buy 24 ounces of Bud Ice.
That's the first time.
The first
That
time.
first time.
Mm-hmm.
The second time
He
when
didn't
came
say,
back-
he did not, the moment he walked in, I said, please turn back. I'm not open for business. I'm waiting for my brother to come and pick me up. I said that to him.
Okay, rebuttal, Mr. Howard, rebuttal.
When I first walked in the door, she said, "May I help you?" And then when she saw that it was me, that's when she said that she was waiting for her brother.
That's the second time.
All right. Brother, you're the brother. Do you have anything you want to say?
Yeah.
All right, step up to the microphone.
Yeah.
Give your name for the gentleman down there recording.
Yeah, my name is Nnamdi Ziko. Nnamdi, N-N-A-M-D-I. Ziko, E-Z-E-A-K-O-R.
Okay. Go ahead.
Yeah, that's my sister.
I understand.
What happened is this. When he was coming back from church, but he told me they broke into the store. I told her, wait for me. Let me come there and see how they broke into this shop, because the building of the liquor store, the building beside it is empty. On the left, on the right, the whole building is empty. So they make a hole. They make a hole inside the building to come to her own liquor store, and then broke the basement door like a ceiling, and then come down to the liquor store and pack everything. So I told her, wait for me, because that evening I was supposed to take her to a meeting, because we always have a meeting on Sunday. So I was supposed to take her to a meeting. I said, wait for me. Let me take this opportunity to see how they break in there, and then I can take you to a meeting. That's the only way he was waiting for me. I didn't know about all this until I came in there. I didn't know about that the inspector came there until I came in there.
Okay.
Yeah.
How many 311 calls have we had?
This wasn't exactly a 311 call. What this call was from where I had been attended, a community meeting, and I'd given the, the participants my cell phone number. And that was someone in the neighborhood, some people in the neighborhood called me.
Do we have do we know what the history of 311 calls were?
I think this may be the first one.
So it's not a community problem. You don't believe it's maybe one or two people after the liquor store?
Probably. I can't say.
Yeah, we don't have a history of 311 calls on this address. I think the last violation was in 2010, as I noted.
Report the burglary to the police?
Okay, the reason
No, step up to the microphone.
Microphone.
okay, about 2 years ago, they broke into the same store through the same way. And I called the police officers, they came, they took fingerprinting, they do this. They didn't even come back to me that this is exactly what they found. And I've been having some problems. Some of them, they come to me, they want to buy something. I say, show me your ID. They be cussing on me. I call the police. The police are not doing anything to support me. If I call them, this is going to be a total waste of time. I say, it's my loss. But I have an alarm in my store right now, and I have a silent alarm in my store right now. No matter how they come in, they are going to get caught.
No, the alarm's gonna go off.
Yeah, I have two alarms, one silent alarm and the other one too.
Very quickly, I just want to make sure we have
the exhibits.
introduced the report into the record.
Yeah, I would like to introduce exhibits 1, 2, and 3. Exhibit 1 is the report that Mr. Howard read into the record. Exhibit 2 is a photo that was taken, I believe, the day of, during the daytime, around 2:30. And then Exhibit 3 is another photo that was taken, and Mr. Howard needs to testify to this, at that evening.
Were these photos taken by you, Mr. Howard?
Yes, they were.
All right.
What was the financial loss of the robbery?
It's about $6,000.
They took $6,000 worth of liquor?
And
Please, one at a time.
Okay, sorry. All the liquor.
Everyone.
All the liquor was taken. All the top shelf liquor was taken. The cigarette was all taken. Newport cigarette was all taken, and the top shelf liquor was taken. All, what's left there? All the shelf was empty. All the shelf was empty.
The pictures are a little, the second picture is a little unclear. I guess this is exhibit number 3. So the second door is open?
Excuse me, I have better.
The color might show better. Yes, just the font, and then that's exhibit 1 and 2. That's 1 and that's 2. I mean, 2 and 3, sorry. I'm sorry, I just handed Commissioner Hayfie exhibits 2 and 3. 1 was the daytime picture, which is 2, and the nighttime picture, which is 3.
Mr. Howard,
Mr. Howard,
step
could you
down here,
come
please.
down here, please?
And up to that microphone.
I just want you to identify. So in exhibit 3, or actually exhibit 2, if you look at exhibit 2, was the door open like that for exhibit 3?
Yes.
When you went there the second time?
Yes.
It's just not clear on this picture. Is there something, a chair there that's keeping the door open? Or is
During the daytime, yes, it was.
Was that same chair there during the evening time? I can't tell.
Lights are on.
Don't think so.
And you don't recall there being one when you were there?
No, I don't.
And were the signs on for the second time you went there?
Was the what?
The open
Open
signs,
sign?
were they on the second time? I can't tell on this picture.
No. No, not the second time.
They were not on.
No. Because when I left the first time, I had to turn it off.
And so you had received, for that second time, you received a phone call from the same source,
Yes.
that it was open. Okay. Thank you.
Can I see those?
At Mr. Howard, Inspector Howard, you said you put in your report at 7:30. You received a phone call. How soon after that phone call did you go back to the establishment?
I received a phone call about 7 o'clock, and I live in Northwest Baltimore, and I just finished eating dinner, so then I got in my car and went over. So it was about 7 when I received the call.
So about
got
30
there
minutes.
yes. So I got there about 7:30, 7:45.
And was it the same time frame earlier in the day? You received the phone call around 2:30, and then
Round about 2 o'clock. Because at that time I was at Sinai Hospital, and I left there to go over.
I think my ruling would be that there is that there is a bless you, that there is a violation.
I agree, there's a violation.
History?
The last violation on file was in June 2010, and that was a sale to minors. So I just didn't want to make sure that it's been past 5 years at this point, but it was right on the cusp.
So it's 0 to 500 or suspension, so. Commissioners.
I don't think a suspension is warranted at this point.
I agree.
Ma'am, we're finding a violation because you were open and you're not supposed to be open on Sundays. And you understand that. And he came twice.
Even though he came, I didn't sell anything to nobody except him. I did not. I usually don't open on Sundays.
The fact that you sold it the first time
Yeah, they
is the
don't like
violation,
me.
okay?
They're jealous of me in that particular
But it's
place.
Ma'am, we understand, but the fact that you were open the first time on a Sunday is a violation. You're not supposed to be open under this
Selling.
license and selling alcohol to anyone under this license.
The financial loss should be taken into consideration a little bit. I would suggest heavily getting a good alarm system, okay?
Yeah, have a
$6,000, but I would suggest a fine of $250.
I agree.
That's it.
250 plus 125 administrative,
And that's 30 days to pay.
30 days to pay. So it's 375 total, but you have 30 days to pay.
Can I pay today?
You
Well,
can pay today.
But you got 30 days to pay.
You can pay today, though.
You can pay today if you want to.
30 days, so you can pay 30 days.
Okay,
Here's your receipt, ma'am.
we're done, we're off the record. Don't roll your eyes, we're off the record.
Thank you.
Thank you.
We will resume at 4 o'clock for the public comment period.
Can't wait.
It's brain overload. You have to
Brain
understand.
overload.
I can't keep up.
Not good. I enforce, the board enforces MOUs if they're part of the license.
So if we agree and the
If we agree and the licensee agrees.
Have you
just like this says,
copies of what?
just like the Court of Appeals said,
Deputy will be bringing
No,
I can
but if they don't have one and the licensee didn't agree, and it's not part of the license,
You could have, they could say, this is what we want in your license, but if the person doesn't agree, we can't.
You can
Right.
pick up a copy there, but we will bring it back by 4 o'clock. But I can bring one over. I didn't bring it with me because I had so much stuff, but I'm bringing it over. I'm going back to get some.
And there was a violation.
Well, I'll walk along.
It's gotta be
Okay,
part,
great.
it's
I'm
gotta be
gonna go right
followed
over
with
there.
this. It's
You
gotta
get
be
a
part of
copy?
the
part of
license.
the license, then
It's gotta be part of the
then it's in a contract between two individuals to which we are not privy. You're a lawyer. Yeah, okay. Yeah, no, I know.
I have a feeling somebody's gonna ask me about that.
Yeah, no.
So basically, the MOU has to be filed with you.
Yeah, we've
Yes.
had cases that they've come in and they say, this is exactly what we want on the license. Now, we don't put it all on the license sometimes, but we put, you know.
We just attach the MOU to the license.
Right.
So at that,
Previously been attached.
Yeah, we just want to check the Director of Finance. I'll take it from her.
Yeah,
Correct. And Fogelman had, under his administration, had a lot of MOUs. We have had some, you know, and we've attached them to the licenses, and for those, we would enforce them.
we don't put it on, physically on the license very
Just
seldom.
attach it.
yeah, at that point, they're enforceable, right?
Yeah. Okey dokey.
And the community can bring a violation on.
Yeah, and do what they want.
They just do.
I mean, it is. I know that I've gotten a lot of emails, so. As part of the dead end, I will put all the comments attached to it, so I won't have to give you these copies.
All right.
Yeah, they'll be part of the comments. Okay. I'm gonna go get the rules and stuff copies.
Yeah, I need a,
Yeah, I'm gonna
Alright.
get everybody copies of the whole.
2:30.
Okay. Well, I don't.
we should have a lot of people.
Well, maybe, maybe not.
Got it, I'll recycle.
Well, you know,
Oh, wait.
What do
Here's
you-
the the rules are your last piece.
Oh, yeah.
oh, is that it?
Yeah, that's the last piece for you.
Oh,
That's your
sorry.
rules.
Oh, this is the current rules?
Yeah, I mean, those are the ones that you're reviewing. Those are right there.
Right.
Yeah, see
Oh,
what you
that's
got.
great, thank you.
And I've
You
got
don't
the
have-
comments too.
But I
from
got
the
all your,
people.
but all your comments, I'll get you an extra set. of comments.
I have the comments that,
You do? Okay, but I'm
oh,
gonna make
yeah,
some, I'm gonna make some copies for you.
okay,
So, I mean, I'll have them for the, get my personal, be right back.
okay. Lunchtime. Where are we going for lunch?
You go over to Warner's, whatever that is?
It's a long walk.
It's a long walk.
Oh, can I get these to you?
Long walk. I don't know, where do you wanna go? We could go to the Hustler.
Good afternoon, everyone. Good afternoon. I'm going to call to order the 4 p.m. session of the Board of Liquor License Commissioners for Baltimore City. Today is December 3rd, 2015. This is our public comment section for the rules and regulations for both adult entertainment and alcoholic beverages. Chairman, I just wanted to make sure that I'm in accordance and making sure that I will give some information on, one, the comments that have been received thus far. I'll give you an update on what we've gotten since November 19th. And also provide you some information from staff, which is also located in the back. I think we put some copies out for the general public in the back. Also, copies are available on our website. On November 19th, we received public comments from the Community Law Center and from the Planning Department. Those comments were placed on the record on both the the city website for Liquor Board, and we have copies for you, additional copies for you, just in case you don't have them, but they were given to you at that meeting. Since then, we've received a letter from the Hamden Community Association in regards to their issues on the record. The rules that they'd like to see changed, I'm just going to briefly, are 2.5C, 2.05E1, Rule 2.07A, and Rule 2.6-7. Those comments are available online, and I have copies for each one of the board members, but I've also forwarded these to you in email as well. The next set of comments that I'm going to be presenting on the record are in regards to the Better Waverly Association. The Better Waverly Group presented a letter to the board, and I'm passing that out to you again now. Also, these were transmitted in email and are available on the website. There is in the Better Waverly's comments, they urge you to look at the public need and accommodation and to put that into the rules. They also would like you to look at Rule 2.07A in regards to submitting documents, Rule 2.11 in regards to community groups being able to request a reconsideration, and then they also made some general comments about safety and welfare of the community. The next set of comments come from the Homeland Association. I'm also passing those out to you right now. This is I believe, a 12-page document. So you have information a 5-page document in regards to a letter regarding the factors again of consideration, the procedure for applying for an extension for a liquor license, and that giving communities more notice in the proposed liquor licenses in their neighborhoods. I also attached an email that was attached to the information, and that was was also posted on the website. The next piece of next comment that was received was an email to Mr. Akris in regards from Ms. Joanne Massapus from the president of the Fells Point Community Association. This was received on the 22nd, and that they expressed that they wanted to support the information that was submitted by the Community Law Center and Ms. Witt. And here are copies of that email as well. Today, actually right before the hearing, I received 2 other pieces of email. We received a letter along with photos from Mr. Victor Corbin, and they are in regards to, and I'm passing these to you right now, 1, 2, and 3. And these have also been posted on our website. They're in regards to 2.05G, the 180-day transfer rule, 4.20C, BD7 licenses, Article 2B in regards to the approval factors, which I think was related into another one, and the completeness of applications. That information that was also submitted in Ms. Witt's letter in regards to that incomplete applications should not be accepted. And then 2.05D, protest of renewal and renewal of licenses. And along with this letter, there's a series of photos that were attached that have also been added in color to our website, and that information has been provided. Lastly, I received a letter from Councilman Henry's office in regards to his support of the information provided by Ms. Witt, and I will give you a copy of this letter. Here's a copy of Councilman Henry's letter from District 4, and I'll get the other copies of that. And that information is, at this point, what we've gotten in, and this information, especially even the ones that were sent today, have been submitted to our website, and they are under comments under the rules and regulations process. So those are the comments from the public that we've gotten thus far. As far as draft rules and regulations from staff, if you would like, I can go through that information. I could put that onto the record. There are some changes that Tom Akris has drafted in regards to Rule 202. And I think it's been highlighted to add that in 2.02, the word application has been entered into A, because to make the subcategories, and to B, criteria to use by the board for approval of application. Staff added the information for public need and accommodation into this section to be in compliance and to add the information that was requested by the community. And then additionally, a section C, used by criteria to disapprove application, has been added as a draft language to the rule. And then other factors is D, which means that the board shall consider any other applicable factors under 2B before making a determination to approve or disapprove an application. And then compliance requirements for the licenses is E, that's been added before a new license or transfer of existing license of a premises, an existing premises or renewal is issued. These are the compliance issues. There's new language we're suggesting new language in 2.14, open and reopen over I want to say 90 days, but the law is 3 consecutive months. There's a procedure for people to make that request. This was in sort of response to the information that Ms. Witt gave us in regards to hardships. We thought it might be cleaner for licensees to also have a formal process in how to request a reopening after 3 consecutive months. So we put together a procedure, which is listed out here as in A, that the licensee will send us a letter for a hearing to reopen, list the approximate date which the establishment closed, provide a check or money order to the Director of Finance, and then give us some required information once they receive board approval. That would be new language that we're suggesting that should be added. We also are asking to add Rule 2.15. After looking at Ms. Witt's information, we're suggesting some language that would say hardship extension requests for license requirements closed more than 180 days. We've outlined a procedure. Our procedure would say that in accordance with 2B, the licensed establishment in the city that's been closed for 180 days may be reopened. The effective license shall submit to the board a hardship extension request, and it would include the following information. A, the hardship extension the hardship has occurred within a 180-day period. Number 2, that the approximate date of the establishments would close and or operation date would be listed in that information. A brief description of the undue hardship that led to the closure of the establishment, and then the check or money order payable to the Director of Finance for $100 to cover the charge of the hearing. Finally, we're suggesting adding some new language in regards to bottle service. This is something that has come up as an issue in regards to an enforcement issue for the agency. So we've defined bottle service and what it is, limitations of bottle service. So bottle service is the sale of bottle or brewed alcohol, non-brewed alcohol, not to exceed 750 milliliters to a party of 3 or more individuals for the purpose of consumption on a licensed premises. B would be the limitations of bottle service, that licensees may offer it to their patrons only under the following conditions. Licensee must issue it for on-premises consumption, that the licensee will provide such service to patrons who are seated at a reserved table or a dedicated bar in cordoned-off area, that if applicable, number 3 would be, if applicable, licensee will have sufficient mixers such as juices, tonics, sodas, and glasses for patrons to utilize for the consumption of such beverages, and the licensee assigns staff to mix non-brewed alcoholic beverages that when they are receiving bottle service. Also, that the licensee also assigns a personnel to that area for proper control. Under C of this section, we're asking for a prohibition on drinking from the bottle. Patrons who purchase bottle service shall not be allowed to drink directly from the bottle. D, from the safe section, would be patrons cannot take the bottle from the premises. So licensees that provide bottle service shall prohibit a patron from leaving the premises with a purchased bottle of non-brewed alcoholic beverages. E, that licensees may store patrons' purchased bottles. Licensee may offer to store non-brewed alcoholic beverages while via bottle services on premises for the purpose of consumption by the patron on a future date. And then F of the same section is to be held accountable. The licensee does not abdicate responsibility for operations under 2B BLC rules and regulations because the premises allows patrons to serve themselves. The licensee shall be held responsible for violations of Article 2B and rules that are caused by the patrons for this bottle services. I'm sorry, there was one more section that we wanted to amend. It's part of sexual practices and obscenities. There was another correction that we did note that we think that we are suggesting language in section C of this. We had that this rule previously did not apply to licenses with a valid adult entertainment licenses. After reading this, we do see that C should not, that section B should not apply to licenses with valid adult entertainment. That A would be, so in our previous language, it needs to be resolved for B only. So those are corrections from the staff, and we wanted to submit those onto the record as part of the comment process. And Tom and I are both here to answer any questions you may have.
And we're open for public comments, correct?
Yes, sir.
Whoever would like to step up first is welcome.
Yeah, right here.
Start.
Hi, I'm Councilwoman Sharon Green Middleton of the 6th District, and I received a call from some of my community leaders in the Park Heights community, which is the center of my district. It's a large community that has the most liquor establishments in the entire state of Maryland in one community, and it's going through a major revitalization and redevelopment. And some community leaders saw the posting of public comments, so I'm here to support them. And I think it's 3 that would like to just share some testimony on some changes of some of the rules and regulations, more particularly the BD7s, I think it is. Thank you.
Thank you.
Hello, everybody. Hello. If I need this mic or not. My name is George Mitchell, and I'm the president of Neighborhoods United, which is a collaboration for all the neighborhood presidents in the lower part of Park Heights, and also Pimlico Merchants Association. I'm also president of Langston Hughes Community Action Association, which is right around Ricerstown and Garrison Avenue. Councilwoman Middleton was absolutely correct. We got more liquor establishments than any community in the world. And you go right up the street to Pikesville, they got 3 liquor establishments, all of Pikesville. We got close to 40. On some blocks, we got 3 liquor establishments in 1 block, 5100 block of Park Heights. It's not good for the neighborhood. It's not good for our kids. It's not good for our growth. And we need to, if these liquor establishments are stepping out of bounds 1 little inch, they need to be sanctioned and they need to be closed down. They sell all kinds of stuff in these liquor stores. I don't know if you know about these new synthetic drugs. I just found out last week something called Scooby-Doo and ice and all this stuff. And these liquor stores and some of these establishments are selling this stuff. And people are going crazy up here. I can't tell you the number of shootings we have in the Park Heights. Just a young man just got killed just last week putting a fence up in his backyard. You know, 3 kids, single parent. I know you heard about it. In my block, the very next block down from where my mom had raised me, and I lived there for almost 50 years, guy got killed, shot, right on the next block, 5100 block of Arbutus, and then doggone it, the next week somebody got killed in front of the liquor store on the other block, on Ricerstown Road. So I beg you and I say to you that if these liquor stores are out of compliance, I don't care if they have a light bulb out. We were able to reduce the liquor stores in the Park Heights by 50. Last year there were 88 liquor stores in Park Heights. We were able to reduce it down to 38 or 40. If they're out of compliance by just a light bulb is out, we need to close them down because these kids do not need to be 38 liquor stores in one area. You need to, and I appreciate your help and appreciate you giving me time to speak. Thank you.
Thank you.
Good afternoon. My name is Cheo Hurley, and I'm a resident of Ashburton. I'm also the executive director for Park Heights Renaissance. We're the organization that is executing the Park Heights Master Plan for Baltimore City, which was adopted in 2008. It's hard to follow Mr. Mitchell, but he's absolutely correct. Our neighborhood has in excess of 40 liquor stores in a 1,500 square acre master plan area, and it's makes it somewhat difficult to move forward with all the redevelopment that we're trying to do. We have 60 acres that are being torn down currently, and we hope to create a new vibrant community within the Park Heights Master Plan area. Today I am here specifically to talk about the draft rule 4.20 that deals with taverns. The current rules have prohibited the transfer of ownership with separated packaged goods stores within a tavern. But we have found that these transfers have or continue to be approved. And now it seems that the provision is going to be eliminated entirely, and this is a problem. The existing rules use the word habitually to describe the amount of on-site consumption that can happen at these taverns. And I think this word is confusing to some people, and it has been interpreted in the past only to mean that people come in and ask, can they have a drink? And I think the intent of this rule is to have people to come into the establishments, sit there, have a drink, have food, and kind of have a good time and then leave. If you go into some of these establishments, there's no real, it might be a chair or a stool in there. People can go in and drink, and that's being considered a sit-in tavern. I believe the board should make its definition on a tavern consistent with city zoning. The present city zoning laws use the word primarily, and this word should be used in your rules, hopefully. Primarily means for the most part or mainly that people will come into the establishment, sit down and drink, and stay there for a while and then leave, not to come in off the street, sit on the stool, drink, or sit in the foyer area, drink, and then go back out on the street. Finally, tavern, we consider tavern, the definition of tavern to be one that, like I said, is primarily there to serve drinks. And the draft amendment would clarifies primarily to include the square footage requirement. I think the current proposal is to eliminate a square footage requirement, but, you know, it's very hard to argue that a place with a very small footprint is going to be able to serve people there for an extended period of time to drink. So I really would appreciate that consideration for myself and also the residents of Park Heights and Baltimore City generally. I have 3 young children that I'm raising here in the city, and I'd like my neighborhoods to move past having so many establishments like this. Thank you.
Welcome.
Good afternoon,
Good afternoon.
evening.
How are you?
It's appropriate. I'm well. How you doing?
Good.
Good.
Like the tie.
I like the tie too.
I like that tie.
Thank you. I can get you one if you need it. My name is Ronald Anthony Mills. So I'm speaking as a resident of Park Heights, but let me also be transparent and say I ironically also work for Park Heights Renaissance, Mr. Hurley, where Mr. Hurley is the executive director. But I've been a resident of Park Heights between adult years and childhood for about 25 years. So in the late 70s, early 80s, the Park Heights I saw then is significantly different than the Park Heights I see now. And I'm here to really address the draft rule about 4.2 dealing with taverns also. And just want to bring to your attention a couple of things that will hopefully spark some interest in amending them in favor of the community. Specifically, in my case, I'll be selfish and say in favor of Park Heights. Most definitions about a tavern describe it as an establishment for on-site consumption. Synonyms for a tavern could be pub, bar, cocktail lounge, or club. Historical names would have been a saloon, ale house, or speakeasy. But if you juxtapose those definitions to the quote-unquote taverns you see in Park Heights, you would wonder who's coming in and sitting down in some of them, because it's not conducive to that. Most of them don't have real space devoted to on-site drinking. They don't have seating, whether it be stools or chairs. And that's if you can get beyond the plexiglass that's in the front of the store. You have to ask to be served, but there's no bartender there. Now, personally, if I'm going to drink, I'm drinking Scotch, Chivas Regal. I don't need a bartender, just put it on ice. But most people like a mixed drink, and you need someone to mix that for you, but there's no one there to do that. It would appear to me that we need something that indicates there should be specific, separate space for purchasing packaged goods, which is distinctly different from where you're going to be seated. I would also say that the present rules require that half of the tavern's floor space is devoted to drinking on the premises, which is consistent with the current definition and historical definitions of taverns. But that requirement is not really enforced, which begs the question, how often do inspectors visit some of these locations? And if you find that they're out of compliance, what is the penalty or consequence for not being in compliance with the existing rules? Your existing rules use the word subordinate to describe the packaged good area of a tavern operation, but the new rules would eliminate that requirement and definition. I would strongly urge that should remain so that there's no ambiguity, so that it's not necessary if a citizens group such as Neighborhoods United wishes to come and bring, a complaint against an establishment, they don't necessarily have to hire an attorney to do it because everything in the rules are clear. We need to place the burden of proof, really, that you're operating the way you're supposed to be on the establishment. If you say you're a tavern, you should be a tavern. If If I walk in and I say I want a drink, it should be clear where I'm going. No ambiguity. If there's no ambiguity in the rules, there's no ambiguity in the operations. That's how we would like to see it. And again, I'm speaking specifically about my experiences 25 years in a specific neighborhood. And so I'll close with this just to kind of give you an example to think about. Let's compare the taverns in Park Heights to the taverns in Fells Point. And you tell me which one are you going to be comfortable sitting in. Not because of the folk around you, but because of the environment inviting you to come in and sit and have a drink. Thank you.
Thank you.
Good afternoon, Commissioners, Mr. Chairman. My name is Christopher Medeo. I live in the Washington Hill neighborhood in the southeast area of Baltimore. Been a resident of Baltimore for the last 8 years. I have a letter that I would like to submit. 4 copies there.
Thank you.
One page each. Sure. Have 4, could call them technical, but I'm a lawyer, so lawyers love technical things here to raise to your attention. Hope that you'll consider them. Let me adjust that. The height challenged. The first, 2.06B, I believe it should be added, a sentence added to the end of that states that the witnesses who testify in support of the allegations, i.e. the witnesses who may be protesting or opposing a license, would also have the opportunity to cross-examine and challenge any of the witnesses presented by the licensee. It doesn't specifically say that. I'm sure that is the process that you all use, but of course, if we're going to call balls and strikes, let's have a good strike zone, right? So that's why I propose it, though the rule does state that the licensee may challenge or cross-examine the witnesses in support of the allegations, it doesn't specifically say that the witnesses may cross-examine the witnesses of the licensee. So that's my explanation for Rule 2.06B, small Roman numeral 7. Rule 2.07, this is the one regarding the notification, the submission, where the rule states that within 48 hours in advance of the hearing, documents should be submitted to the board, and if they are not, they will not be considered unless the person presenting them is present. I believe that paragraph should be stricken in its entirety. Although I understand it can be difficult to review things presented for the first time in front of you that day. That's exactly what judges do in the District Court of Maryland. And obviously you can give it the due weight it deserves if the creator isn't there or if you believe it's not an authentic document for whatever reason. However, to have a blanket prohibition on allowing a document doesn't seem fair or in the best interests of justice. So that's why I note in there that I don't believe it should be more difficult to admit evidence in a hearing in front of the commissioners than it is to admit evidence in front of the District Court of Maryland. Item 3 is Rule 2.11A and Rule 2.12A. Those regards the request for reconsideration and the request for a petition for judicial review. Those rules state that the licensee may request reconsideration or the licensee may request judicial review. They do not state that community members or individuals protesting the licensee may request a reconsideration or judicial review. Again, although that may be the process used in front of you, I believe it should specifically state that. Obviously, that would be kind of patently unfair to not allow such a thing. And finally, Rule 2.11. This is, sure. I just think it should be added that if there is going to be consideration of a request for reconsideration, unless you're willing to deny the request based on the papers, there should be a hearing scheduled with the same procedures and notifications of any other hearing, such that the party opposing the request for reconsideration can come and present testimony, arguments, and whatnot for the reason and basis for that opposition. Thank you so much for your time today. I appreciate it.
Hello? Sorry, just want to make sure it worked. My name's Shannon Wren. I am the president of the HCC, the Hamden Community Council, and I wrote in a letter, which I believe you guys have all received. My main concerns were about MOUs and timing. I think some of my concerns were addressed by the previous speaker as well. And so if you guys are offering any sort of clarification today, it would be really nice to understand a little bit better the board's position on MOUs, as well as sort of allowing time for community input.
Just the letter?
Yeah, that one's
Oh, you're the lady that wrote the editorial.
Yes.
I'll address this, not that we are addressing issues, but I think that we went on the record earlier, and I addressed your editorial. I asked if you were present. You weren't. But
I have a full-time job, as
That's
do many
okay.
volunteers.
I'm not. No.
Don't worry
That's
about
okay.
that.
You quoted BOLC versus Fells Point Cafe, which held that the board may place restrictions on a license with the consent of the licensee. That was your quote. That's what we do. I don't know where you got your information from, but that's what we do. Okay, so your editorial was patently incorrect.
Sir, if you go to hour 1, minute 11, I have not misquoted you at all, and you said that
That's
you do not
what
enforce
we
MOUs.
do. No, we do not enforce MOUs that are issued by the community on their own with licensees unless the licensee consents on the record, which they do, and then we enforce them. And that's what we do.
That's great clarification, Ben, because
Okay.
I don't think that was clear previously.
Okay, well, it's clear now.
Thank you.
You're welcome.
Thank you.
I have copies for you.
Okay.
My name is William Miller. I'm the president of the Northern Police District Community Council. The council is the public safety forum for 60 neighborhoods and associations, 6 business districts, and 3 institutions of higher education in north central Baltimore. You've heard from some of our neighborhoods individually, but I should mention at this point, I've heard from a number of neighborhoods because of the neighborhood cycle that they don't meet except on a monthly basis. There are neighborhoods that have not had a chance to meet and decide on how to write a letter to you. So I hope that the record will be kept open for a while so that neighborhood associations have that opportunity. While the majority of liquor licensees in our area are viewed as assets in the community, we have a few problematic establishments that contribute to damaging our neighborhoods, our business areas, and consume an enormous amount of time from public safety resources. As the board considers the adoption of new rules and regulations, we want to be sure that these rules and regulations do not favor these problem establishments and make it more difficult for neighborhood groups to seek remedies. We really need your help. The decision to roll back the penalties on the Stadium Lounge, the failure to follow up on your call for the Stadium Lounge to enter into an MOU with the community, the failure to seek public input in the beginning of the rule and regulation process, failure to provide adequate public notice for the first meeting, all raise questions in the mind of residents about the direction this board is headed. As the Baltimore's health commissioner pointed out, the board's priorities should be the public health and public safety of the community. We wish to associate ourselves with the letter and technical comments that were submitted by Becky Witt on November 18th, 2015. In addition, we have a few other points that we want to highlight. With respect to Rule 1.4D, when an MOU is entered into by the licensee and the community, we want the provisions of the MOU to be officially part of the record and be enforced by the board, similar to an MOU in a zoning case, which was not done, by the way, in the Stadium Lounge case. We urge that the deletion of Rule 2.07A so that community members are not subject to the burden of submitting all documents 48 hours before a hearing. Most community groups operate on a 30-day cycle, and hearing notices already place serious time constraints on responding in a timely fashion. We urge the amending of Rule 211 so that both parties, both community groups and licensees may request a reconsideration. We hope you will add a list of the specific factors the board must consider in determining whether to approve an application. And we think there's a need to spell out procedures for applying for an extension of time to keep an unused liquor license unexpired, that's been unexpired. We hope you'll make these changes before approving the final document. And in conclusion, we want to hope that when you're finished with this document and it becomes official, that the board, or representative of the board, will come out and make a presentation to the 60 neighborhoods of north central Baltimore. Thank you.
Thank you, Commissioners. My name is Joan Floyd, and I am a 20-year resident of Remington in North Baltimore. I have dealt with liquor board issues both as an individual and also as the Vice President and now President of the Remington Neighborhood Alliance. We've been involved in expired liquor license issues going back 15 years, application issues. I apologize that this is my first opportunity to be involved in this ongoing process. I appreciate the work that others have done. Normally I would be involved, but a lot of other issues, especially zoning, have been taking up a lot of our volunteer time. I want to make sure that when I looked this morning for the first time at what was being presented, I want to make sure I'm using the right document. I'm looking at a document that does not have any red lines in it, and it's called Revised October 2015, and it was provided, I think, by email. I want to address 4 issues in that document. First thing was touched on, I think, by one of previous speakers, on the issue of appeals. The rule, and I'm sorry, I actually don't have the rule number on the appeals. That was not.
2.12.
Thank you. Yes, thank you very much. It appears the rule is written as if only licensees ever file appeals. Appeals are filed by unsuccessful applicants, and they're filed by protestants. And so the procedure that's in that Section A needs to apply to all appeals and to all appellants. So it needs to be done, rewritten in some way to make that clear. And then as far as C of that same rule, the reference in C needs to be to the appellant rather than to the licensee for the same reason. Now, I want to point out 2 things the rules do not address. They do not address the removal of restrictions on an existing license, which, and it was touched on, I guess, that one of the things that might be a restriction might be part of an MOU, but there may be other things as well, including ongoing restrictions that have been placed on licenses over the years that we see on those old cards that we look through when we come to the office. The rules do not address the removal of restrictions on an existing license, which is an amendment to a license, which does require an advertised public hearing, and I just didn't see anything about that in there. The other thing that I noticed, and again, I've only had a chance to read these once, and this is something I really think is important, and I've never seen it addressed. The rules do not make a distinction between public right-of-way and private property as part of a licensed premises when there's outdoor seating involved. How can public right-of-way be made a permanent rather than temporary premise for the sale of alcoholic beverages? That's something that's always seemed problematic, has never been addressed, and it would seem that there would, even if it can be done legally, there would have to be some kind of criteria for approval. There would have to be some distinction made when the board is considering whether the outdoor seating is on private property or on public property. So those are 2 things that the rules do not address. And going on to the contract purchaser issue, I don't know if you've heard a lot about this from people. I've heard a lot about this from people. I honestly would like to know where Article 2B actually authorizes the board to approve the transfer of a license to a contract purchaser who then, quote-unquote, holds the license. The holder of a license, that's a term that shows up in the Article 2B a lot. and it gives certain privileges if you're holding a license. So if you're talking in the rules about transferring a license to a contract purchaser and you're doing it basically administratively without a hearing and so forth and so on, and now suddenly you have a holder of a license who hasn't gone through the process of becoming a licensee. And frankly, I think that to us in the citizenry, in the neighborhoods, the whole contract purchaser issue really makes licenses property to be treated as commodities. And it validates straw purchases, and it basically functions as a way to avoid license expiration. And I think that years of discussion have made you all aware that that's not a popular approach. The last thing I want to address, very, very important, Rule 2.08, what we used to call the 51% rule. It's called the 50% rule here. The way it is written, I was actually shocked when I read this, the way it is written, because it creates different classes of people who can participate, and it deprives property owners and some tenants of due process. Because the way it's written, only certain tenants, so a certain class of tenants, is allowed to submit affidavits. Now, I've been through this process. Went through this process 16 years ago. It's an arduous process. And the affidavit requirement of having a doctor's or employer's statement or having to be more than 50 miles away is sufficiently strict to apply to everyone who wants to participate in this process. But the way it is written, you only have certain people allowed to submit an affidavit. Only the second tenant. Not the owner, not the 90-year-old lady who's bedridden, who owns the property, not someone who owns the property and is living more than 50 miles away. You've written it so that only you create a class, two different classes of participants. I don't think that's right. I don't think it's legal. I don't know. But that is shocking, the way it's written. So if that was the intention, that needs to change. If that was an oversight, it can easily be changed. And I just, as a technicality on that same rule 2.08C, the first line there is another problem. It's very problematic. Actually, it's not just technical. The first line says, should any owner, and it should say, should any tenant. Whatever problem is you're trying to solve with that sentence, what you're doing is creating a problem with that sentence, not solving one. And I'm very happy to follow up with any kind of, I'm very happy to follow up on this issue in particular. Thank you.
Have you submitted this in writing?
I have not. I would prefer, rather than give you the copy that I have, which is not, I would prefer to follow up with a written, if I can, if I may.
That's fine.
Thank
you.
you.
Have plenty of time.
Thank you.
Thank you.
I know it's on 2B.
Good evening. How are you today? I'm not going to reiterate most of my letter, but there are some things that I just want that concern me. The protest of renewal. We went to a case a couple of months ago where a community association filed a protest of renewal, and we were told to file it before the 31st of March. And because we did that before the application was submitted, it got remanded back to the board. So I would like to see in here that the community would have 30 days from the date the application was submitted, because often license holders wait to the very last minute to file the application, or the very last day, the last hour, last half hour, or they file it late. And what are we supposed to do as a community? Camp out in the liquor board that whole last day to make sure that we get it in the record. So that's one thing I think that needs to be fixed. The judge saw that issue when he remanded it. He actually said he would give the community 30 days to file the protest. The other thing that really bothers me, and I'm like Joan, I'm a little late to the game. I've been out of the country, and I haven't read all of this thoroughly. The reconsideration definitely should include the community. Often the community does hire an attorney for Community Law Center to do a lot of their cases, and sometimes we do our own work. Also, the BD7s. The BD7s I have a big issue with. To me, currently, there are a lot of licensee holders that are basically, I call them faux taverns. They're really not taverns. They're liquor stores. We all know what they are. They put 3 bar stools in the back of a room against the wall. You never see anybody drinking anything, but they've got alcohol stacked from the floor to the ceiling everywhere. And like I said, I haven't gone through that section very thoroughly, but there needs to be some tightening up of that, what a BD7 is. I don't like the idea that we're going to loosen the requirements for BD7s, and the reason is because of the impact these BD7s are having on the greater community. Fells Point has over 20 BD7s right now. I know there's been an argument made by many of the attorneys that sat on that committee that the BD7s are being used by good licensee holders such as Cindy Wolf. Bin 604 is constantly thrown out as an example of a good BD7. Yet you go into her establishment, I go there quite often to buy wine. I consider it a liquor store. I don't consider it a tavern. I never see anyone sitting there drinking. And if that's the case, then she should be held to the same rules and standards that everyone else in Park Heights and around the city should be. Same goes for Chesapeake Wine Company, also a good establishment. But these are smart business owners. They knew what kind of license they were buying. And we all know the reason that people are using the BD7s. The BD7 allows them to sell alcohol till 2 o'clock or 7 days a week. Most of the good licensee holders that have them, that are basically liquor stores, wine companies, etc., do not open at 6 a.m., and they don't stay open till 2. My solution to that problem, which I've offered as possible legislation, would be to create a new class of a Class A license, which would allow a liquor store to stay open 7 days a week. But they would be restricted to the same liquor, the hours of operations would be restricted. So I think that would be more of a solution. And then anyone that has a BD7 currently that operates as a liquor store could be told that they have a certain time frame where they should have to change that over to the BD, I guess you could call it a Class A17 or something, add a 7 to the end of it so they can stay open 7 days a week. Because what we're seeing in Fells Point, especially the upper part of Fells Point, the Broadway corridor, is the BD7s, they are morphing into liquor stores. And the consequence of these liquor stores are public intoxication, people all over the place, drunkenness from 6 o'clock in the morning till 2 o'clock, people in front of churches drunk. And these are the ramifications that we have as a community. People just sitting around drinking all day long. Fells Point has 48% of the liquor licenses. And if we end up getting more BD7s and they morph into liquor stores, it's going to drastically reduce the quality of life that we have in Fells Point. The Broadway corridor is struggling. nobody wants to go north of Eastern Avenue anymore. And that's mainly because of the BD7s that are operating as faux taverns. And I would like to see that the board tightens up the restrictions here and the rules. I also have to make a final comment. The Community Law Center is widely respected by community leaders around the city. And I would highly recommend that you guys sit down and talk to Becky Witt. I think I read through her recommendations. I think most communities across the city like what she wrote. We feel that I personally felt that she should have been on the committee at the very beginning, but I hope that you adopt a lot of her suggestions, if not all of them. Thank you.
Thank you.
Sorry, you guys, you're gonna have to bear with me. I'm losing my voice. I'm Christy Anderson. I'm the president of Fells Prospect Community Association. We had many concerns that I think were shared, particularly with Victor and Joan Floyd. And I'd reiterate everything they said. And I just wanted to also clarify our letter. I didn't see it in the comment section or hear it read out, but we supported what CLC submitted. And we also wanted to comment on the BD7s.
I can make sure that I'll double check on the comment section issue.
I mean, it basically just reiterates what Becky had said, but we are concerned about BD7s in particular because we hold a lot of those licenses in the greater Fells Point area, particularly in Fells Prospect, Upper Fells Point, in that area. They are subject to the most abuse and misuse than any other license, I think. And this license allows for bars to operate as liquor stores with no qualifiers like food sales and no way to regulate the on-site consumption. A great example of this is a tavern that recently reapplied for a license. It has been postponed, but the floor space shows it as a liquor store, not operating as a tavern whatsoever. And this was put on the docket, and that's concerning because it clearly shows, first of all, that their application is not for a BD7, which is what they're trying to transfer in there. It is what a Class A license would look like. And the presentation by the licensee to the community called it an upscale liquor store. And then he later called it a tavern. So you can see where the licensees are even confusing BD7s with Class A and liquor stores. And that is something that we struggle with a lot. Let's see. And after the release of the 2013 audit and the alcohol density study, the city and state legislators also committed to decreasing alcohol density as recommended by a national study. And the proposed rule change that was mentioned about 5 BD7s per licensee, it was briefly mentioned. I don't know what the deal with that was, but that was in the PowerPoint presentation, directly contradicts what was recommended and promised to the citizens.
Those are the comments from the,
It was
that's the last page, which were the legislative recommendations from the actual committee. It's not part of the rules.
Just making sure. There's a mention to change Rule 1.12, which is the special Sunday one-day license for Class A and D licenses in the presentation that suggests increasing the limitation of the licenses. Is that in the regulation draft, or was that just in the PowerPoint portion?
I'm sorry, which one was it again? That's
It was-
2.12?
It was 1.12, the special Sunday one-day license.
We expanded and put information in there that hasn't been
Okay.
included before, so that's what's part of the PowerPoint, to basically say that we've explained that process. That process wasn't previously in the rules. So it currently is listed in the rules, and that was an internal staff process that has now been listed as part of the rules so that people have more clarity and transparency of what the agency's doing.
And
And all the special Sunday licenses and the supplemental licenses are all found in Article 2B.
so was there actually a suggestion to increase the days that they are allowed? Okay.
No, that's just, that, it just
Comment.
puts it into the rules. It wasn't in there before.
Okay. And then the residency requirement was another concern that we had. I understand that that's part of Article 2B, but it was also suggested in the draft as well. I think that the residency requirement, personally, and as representative of my community, is really, really important because it presents a financial investment in the city for somebody that also lives here, who pays taxes here, who sees what they're doing. Because what we have a lot of times are these people that hire straw men licensees, bring them in, and they don't care because it's not their area, it's not their problem, and then they do as they please and go home to their house in the suburbs, not having to deal with this. They don't have to deal with the bar noise. And we do choose to live here. However, you know, we do live here. We invested in the city. I personally grew up here, so I have, you know, a lot of ties. And I think that changing that residency requirement would be detrimental.
That was a legislative change.
It is, but it was still suggested, and you know, I think that it's important to address that as well because the legislators are supposed to, and delegation is supposed to represent the people that basically voted for them, but the people in their districts, not just the interest of business and liquor licenses. And I think that that's very important as well. Victor and Joan actually covered most of what I was going to say, so that killed the rest of it. But thank you very much.
Thank you.
Good afternoon.
Good afternoon.
I'm Stan Wilson. I'm Secretary of the Homeland Association, and we represent 957 homes in North Baltimore. Our president has written you with his suggestions and concerns. Briefly, we would like to see a list of the factors that the Liquor Board must consider in determining whether to approve an application. It would be very nice to clarify the procedure for applying for an extension of time to keep an unused license unexpired. And if licensees can request reconsideration of the board's decisions, the community association should as well. Finally, we've worked very successfully with Councilman Henry and the neighborhood associations on both sides of our stretch of York Road addressing liquor issues, and we have the highest regard for the Community Law Center, which has been very effective in working with us. And so we would ask that you give every consideration to the suggestions that the Community Law Center has outlined in their 6 pages in their letter to you. Thank you.
You're welcome. Thank you. Thank you.
Good to see you all again. Mark Parker on the board of the Highlandtown Community Association. I very much appreciate, sorry, Commissioner.
That's quite all right.
I very much appreciate 214 and 215 being added for clarification on the reopening after 3 consecutive months and the hardship. I wanted to follow up on 214 just to see if I'm missing something or maybe something needs to be added. So request to reopen after being closed for more than 3 consecutive months and under A2, the approximate date when the establishment closed. We have a number of establishments who try to circumvent being closed whatsoever, even though they are in fact closed, right? But they receive illegal shipments of alcohol, so they have receipts showing that they have in fact received alcohol there, but then they don't sell it there, they ship it off somewhere else and sell it from there. And so it would be helpful to clarify what exactly the Liquor Board means by an establishment being closed, and that there be some documents to provided reflecting what closure actually means. And I would say that would be part of the renewal process itself, that under the application for renewal, I notice under Standard of Operations 303, records being kept. One of them is receipts of alcohol purchased from the wholesaler, and then the second is receipts representing alcohol sold on the premises. But I don't see that actually, so that would demonstrate kind of an active business operating there. Maybe it's covered under the application for renewal itself, but it's not spelled out that those receipts be part of what's submitted as showing that not only are we here to apply for renewal of the license, but it is in fact active. We're actively doing business here. We haven't just pretended to do business for the last year, and now it's renewal time, and we have some some papers that don't really support what's going on. My question on 215, the hardship extension, and again, maybe this is there, or maybe the staff of the liquor board can comment. So it clarifies the length of time that a establishment has been closed, that at which point, 180 days, at which point you would request a hardship extension. How long does a hardship exemption last for? Is that the discretion of the board? Is there a range, or what's the? It'd be nice to know how long that can continue before the reasons given are not as good. It would also be helpful to know what the grounds. So it says a brief description of the undue hardship that led to the closure of the establishment for 180 days. It'd be helpful to get some clarification from the liquor board about exactly what might qualify as an acceptable undue hardship and what might just be smoke that they're trying to blow up your behinds, right? So, but some clarification as to what is, so that applicants, the licensees know when they come here on what basis their request for hardship exemption will be considered. Or is it just make a case and you guys will decide, how compassionate you're being that day, right? But I think that would be helpful as well. How long a hardship extension can be extended for, and then also what grounds are being used to consider it. Thank you, guys.
I had one last comment that I forgot earlier, if that's okay. I had another concern that wasn't about the regulations itself, but how the committee was comprised. The two areas with the largest liquor licenses, Fells Point being one that holds roughly, I believe it was like 46% at one time of all the licenses, had no representative. And that is a concern because this is being presented and changing for all of us, but in particular, the places that have the highest concentration had no representative. And this has been brought up many times, but there is almost no community representation at this. It was almost solely comprised of people that have a financial interest in liquor licenses. These rules are not just for licensees, but for communities. We want to have hospitable environments to these businesses. We're not anti-bar or anti-liquor license. It's what's helped develop some of these areas, but it's also important to find a balance and have equal representation, and I think that this committee greatly missed that, and that's all I wanted to say about that.
Come on, Victor, we got all night.
Mr. Parker brought up the 180-day rule, and I guess I have a question about that because 180 days in my mind is 180 days. I understand that you can make one hardship extension, but my question is there's nothing in the rules that address when someone puts in an application for a transfer. And then this has happened in Fells Point many times. So you put in an application and it stops the clock. So then it sits there, the application, and a licensee postpones time and time again. And I know there's one currently in your file that's been postponed so often that the license is over 900 days old. It's been sitting there at the liquor board in an application. So there's nothing that addresses the postponements. And to me, it seems like this is a way to circumvent the 180-day rule. I'm compassionate if you had a fire or a death in the family or something and you had to shut down your business temporarily and you're given an extension, I get that. I think there needs to be distinct rules. I don't think it should be up to the discretion of the board, with all due respect, because if not, then, like Mr. Parker said, if you're in a mood one day, then it won't be applied equally. And finally, these rules, speaking of being equal, they need to be applied equally all the time, because often the community feels like we're getting slighted. We're told 72 hours to ask for postponement, yet a liquor establishment comes in the day of and gets the postponement. If we want the postponement, we're told 72 hours. Paperwork. It's provided by the community, which basically gives the applicant our entire case. Yet when we want their entire case, often they slip in things the day of. Application changes. They're changed the day of. Yet we're told we're not allowed to do different things. So I'd like to make sure that once these rules are if they are adopted and when they're adopted, that the rules are applied fairly to both the community and the applicant. As far as the legislation recommendations, I'm a little concerned that this was even discussed at all. Because it's one thing if the board wants to make recommendations, but I take issue with the fact, like Christy said, I felt the committee also weighed very heavily to liquor interests. And basically, all of these 6 proposed legislative changes sound like any one of the lawyers that's sitting in this room today, they wrote it. And there was no input from the community, because a lot of us take issue with several of these, specifically the BD7s, being able to hold 5 of them. The rule, 180-day rule is a big issue. The newspaper rule. I mean, first of all, quite honestly, I haven't had a paper delivered to my house in probably 10 years. I do everything online, so that's an issue. And which publication are we going to use? The rule of record? I don't get that. So that needs to be, I think that needs to be tweaked for the modern day. And some of the other ones I won't go into detail, but I do take issue that this was even discussed at that hearing, at the committee. Thank you.
Welcome.
Hello,
Hello.
my name is Ivor Yamrush, and I'm with, I live in Federal Hill, and I've been a
Again, spell your name.
IVO JAMROSZ. I've been here before many times, but none before you, so this will be a new experience for everybody. I first of all want to say thank you so much for keeping us in the loop, the Community Law Center for addressing these issues that laymen like myself can understand and pass on to our neighborhood. I'm the chairman of the Liquor Advisory Committee of Federal Hill Neighborhood Association. And unlike what other people have said, I think we have the largest number of bars in the city. I think we should have a fight here as to who has the largest concentration. I think Federal Hill usually, or South Baltimore usually wins. What I really want to address is something that's not addressed here, or not really sure that where to find it, and it is the problem that we've been having most recently. Things are pretty quiet in the neighborhood, thank you very much, but we're having major problems with the bar crawls. And as I think you've probably seen and heard, the Halloween was quite an extravaganza. I think they sold more than 5,000 tickets. They're sponsored theoretically by a nonprofit that's not a nonprofit. And as we go from one area to another area asking for help in making sure that this does not get out of control, as it did particularly with the Irish Stroll, how do we get your support, and how do we get the neighborhood protected from what everybody's got pictures of? You can go on YouTube and everywhere else. Sexual deviancy, all kinds of abuses. And, you know, we're really concerned particularly about the young people who abuse drastically alcohol. We've talked to our state delegation. There's potential of some kind of a legal introduction next year. But I want to see if there's anything that you all can help us with to prevent the kind of mayhem we've had in the past.
Okay, I mean, we have submitted some information to Delegate Hammond
Yes.
in regards to bar crawls and some suggestions on how to deal with this as far as legislatively. So it wasn't addressed in the rules because we believed that we needed additional legislation to enact anything, if I can be correct.
There are a couple jurisdictions that have bar crawl legislation, Arlington, Virginia, particularly Washington, D.C., and those were passed by local ordinance. So there needs to be some legislative action taken before any kind of rules or regulations can really be.
So we can't use your Rule 110 that's talks about temporary special event licenses?
We sort of, that's why in some ways we did start to deal with the larger events. It's 500 in regards to that, to ask for a little bit more scrutiny. So that's what you do see a change in that in regards to our processes. And I believe that Tom has, and he'll confirm the fact that we've been working on our one-day licenses to basically deal with larger scale events and requiring more information regarding security, police, and all the information, so that in some ways with the Irish Stroll and other events of that size that we have in our internal processes, better communication with other departments. So that we've dealt with on the one-day side, but bar crawls in particular, I think still needs additional legislative help, and because since we are a state or state agency in some ways, that's the reason why we've deferred that to the delegation.
That's great. Can we also make sure that the neighborhoods that are impacted by these bar crawls get alerted that these things are happening, or that that we'll have at least a day or two to to protest if we have to? Thanks very much.
Thank you.
Thank you.
We, just to conclude, we still have time for written comments. How long, Michelle?
The final adoption of the rules is on December 17th, so that the board will meet in an executive session in the next week in regards to this. So I think that there's still more time, and I will make sure that any comments that we get are forwarded to the board up until the date of the approval.
And I will say that some of the suggestions that I think are excellent suggestions,
Will be taken.
the board was charged to change the rules last year. Didn't happen. Happened this year. The last time the rules were changed were in 1998. So we're doing the very best we can. And we've had 2 open meetings now, one during the day, obviously one in the afternoon. And we will have community outreach meetings. I think 6 are planned for the next year, correct?
Yes, sir. And that
All over the
press
city.
release, will go out shortly.
Right, all over the city. So, we hear you, we're here, and we're listening. You may not think we are, some of you, but we are, okay? And we thank you, and you still have time to make comments. Thank you very much.
Thank
Have a nice
you.
evening.
Thank you.
We're off.
These were the only 2 formalized that I got?
Yeah, that one,
And I will
and
make
then
sure.
there was.
No. What? Huh?
What did you say?
He said he was prepared for the long haul.
Oh, I know.
So what we'll do is
Wasn't bad.
send that out, but I'll give
Good point.
I've got mine.
I have a card. Here, just give me your card. I'll shoot you an email. Yeah.
I like his tie too, but I can never figure out how to tie
can
it.
never tie 'em.
I wouldn't know how to tie it, so.
You're talking about Pop House Renaissance?
bow tie.
Over there?
I know, but I
You must practice a
tie
lot.
a bow tie. You don't understand, I'm not good at those things.
Just to do community outreach, we were passing
4.5
rules.
hours.
They're going to be published in January. Here to have a conversation.
What was 4.5 hours?
He had a setup.
We have no problem.
Don't want to necessarily talk about
He couldn't keep his
business
client
per
up.
se,
My
but
client
it's
was
more kind
fine.
of an outreach
My
effort.
client was good.
Who?
And in fact,
Yeah.
He had a real estate settlement that went down, went south. And you're gonna get
Done. Yeah. They're done. Yeah. Correct. And if if you have like any questions about, that's, you know, kind of being hashed out. So, you know, probably you can't be all three staff. You know, probably just one commissioner.
No, we're not. We just sit around here waiting for comments.
We got a lot of them today. So, yeah. Yeah, definitely.
Yeah.
Thanks, Mark.
We're trying to be as transparent and open to the community
What do you mean?
as possible. That's me.
You have to get that evidence over months in advance.
Oh,
Bring
they're-
something up in
they're-
court that hasn't been brought up before.
What?
Jessica,
How you
thank
doing?
I understand his
Mike.
point, though.
The 48-hour rule, I think,
Yeah.
listen, the last time I was here and had a bunch of exhibits, I did everything over 3 days before, the community did.
That's a toughie. Hey,
Otherwise, here's what happens.
Everyone's going to submit it.
First, file lost letters the day of. Yep, make it simple. Some of these
Bill
council
Henry sent a letter in. He's in Seattle. I spoke to him this morning.
He had his people send it.
I understand, but he's in Seattle.
How do you sign it then?
Hi, Mike, Doug Trotter. Nice to meet you.
Did Robo sign it?
No. He had
Oh, do
he had
you?
a staff member sign.
I live on Charles Street.
He had a staff member sign. But
I
he's
live
in
on that one-way portion,
Seattle.
right below St. Paul. Uh-huh. I live
He ruins
30,
your neighborhood.
30 years.
He tries.
Moved there about 3 months ago. We lived in Federal Hill.
Oh, okay. Oh, you haven't been to the welcoming. We usually have once a year in February. We have a welcoming of the new people that moved in. So we'll see you there. I don't know where it's going to be held this year.
I'm not going to be able to make the party on Saturday.
What's the party?
Holiday party.
Oh yeah. Oh, that. We used to host that. So, well, good. You're here representing what?
Well, my wife owns Canton Crossing Wine and Spirits.
Okay.
And I'm working on trying to get the Licensed Beverage Association in the city.